So one of the things that we've been focusing a lot on the department is clients with mental health disabilities and how those intersect with the practice of criminal law. Stacy, I'm wondering if you can set that up for us in terms of what is the insanity defense?
So, the insanity defense is whether a defendant was laboring under such mental disease or defect that he did not know the nature and quality of the actions he was doing, or if he didn't know that he did not appreciate the wrongfulness. And Robert, just to clarify, there's the insanity defense is usually misunderstood, and there is this misconception that because somebody asserts the insanity defense that they're trying to avoid criminal responsibility or escape punishment. Do you believe that it is true?
Yeah, I think you've got to pick the appropriate circumstances and the appropriate case for it as to when to, put forth an affirmative defense in insanity. I mean, you have to understand, I think that, that if clients try to fake their way through this, that's not going to work. They're going to go under deep scrutiny, their mental condition to determine whether the disease is actually, in fact, real or not. And not only would you put your client out there for evaluations and a full history of his medical records, but you got to expect state is going to do the same, and push back on that to determine what truly would qualify as an insanity defense and what, would otherwise not.
And just so people understand, there is a difference between the insanity defense and competency to stand trial, correct?
Oh, absolutely. So, yeah, and so it's really like look at this in two things in two parts. One is competency, right? And competency is going to be the time of the case proceeding, from arraigning to conferences to even a plea agreement or trial, any stage within the litigation to determine whether the person understands the nature and circumstances of the case, what he or she is charged with, what the prosecutor's role is, what the defense attorney's role is, what the judge's role in the case and the jury. That's competency, which is different from insanity, which would look back on at the time the alleged offense committed, what was the person's mental state.
So, at the outset of the case, should you be considering both the insanity defense and competency to stand trial?
I would say certainly yes. You have to, if you suspect that your client is suffering at the time or suffered or had suffered at the time the offense was allegedly committed, you want to look at both, right? And I think you want to do a few things. And you know this, Stacy, because you've done it in the cases that we've handled together. You've gathered the medical records. You've spoken to the family. You've spoken to people about what sort of treatment and what sort of prior instances, may have been at stake. So you really need to do your due diligence on your client's own mental health.